Although treaty suspension remains a rare course of action in international law, its mere invocation or threat may sometimes function as a powerful diplomatic lever, prompting renewed compliance and preserving the treaty's integrity without resorting to the full termination. Hello, everyone. My name is Miki Sivraja. Today, I'll analyze a complex scenario involving two states, Aramika and Botuna, concerning a treaty dispute under the Vienna Convention on the Law of Treaties. The case revolves around the unilateral suspension of a bilateral dam treaty, allegations of material breach, invocation of fundamental change of circumstances, and the emergence of jus cogens norms related to the access of clean water. To understand the Aramika and Botunia dispute, we must first examine four key principles from the Vienna Convention of the Law of Treaties, which govern treaty performance, suspension, and invalidity. First, Article 26, Pacta sunt servanda, means every treaty in force must be performed in good faith. It is the bedrock of international law, ensuring trust and predictability. In the Namibia Advisory Opinion, the ICJ reaffirmed the principle when South Africa's continued occupation of Namibia violated its international obligations. As Alfred Woodross described it, it is both a legal and moral obligation. Second, Article 60, which is material breach, allows the state to suspend or terminate a treaty if another party seriously violates a core obligation, either through repudiation or violation of essential terms. For example, in the Nicaragua case, US attacks on Nicaraguan ports were ruled breaches of their treaty. However, humanitarian treaties and some others are excluded from this provision, and procedural steps like notice and negotiation are required. Third, Article 62, which provides fundamental change of circumstances, also known as rebus sic stantibus, allows withdrawal if unforeseen, radical changes undermine a treaty's purpose. But this is a rare exception. In the fisheries jurisdiction case, the ICJ rejected Iceland's claim, finding the change in fishing importance did not meet the high threshold of fundamental. Finally, Articles 53 and 64, jus cogens refer to peremptory norms of international law that override all treaties. If a treaty conflicts with such a norm, like the prohibitions on genocide or torture, it is void. In Bosnia and Serbia, the ICJ reaffirmed this. However, rights like access to clean water, while morally compelling, have not yet been recognized as jus cogens. Together, these four principles shape the legal boundaries within which Aramika and Botuna's actions must be assessed. Aramika's argument relies on Article 60, claiming Botuna repeatedly violated environmental safeguards leading to a material breach. Aramika's legal basis falls under Article 63 of the VCLT and not repudiation. It argues that Botuna's repeated failure to implement environmental safeguards constitutes a violation of essential provisions central to the treaty's object and purpose, which is sustainable joint river management. Aramika may choose to then argue that Botuna's sustained non-compliance with environmental safeguards amounts to a material breach under Article 63b, which defines the breach as a violation of a provision essential to the accomplishment or the object or purpose of the treaty. If environmental provisions were key to ensuring equal ecological balance or sustainable water use, Aramika could claim the breach goes to the heart of the treaty's purpose. However, to counter this, Botuna may choose to argue that Aramika fails to demonstrate any specific clause has been violated. The reference to a repeated failure lacks legal specificity and evidentiary support. In Oil Platforms Iran versus US 2003, the ICJ rejected a claim of material breach where the breach was not clearly established or directly connected to the treaty's core obligations. Additionally, in Gabichoko Nagimoros, the ICJ ruled that even a significant environmental concerns did not justify unilateral suspension because the treaty included mechanisms for adaptation and the parties had not exhausted cooperative procedures. Further, if Botuna's actions were undermining the treaty's sustainability, Aramika may claim its suspension was a form of self-help, taken in anticipation of further harm. In response, Botuna may counter by assessing that Article 60 does not permit preemptive or anticipatory suspension. The breach must be actual and material, not speculative. In Gabicho, Hungary suspended construction, citing environmental risks and international concern, but the ICJ ruled this suspension to be premature. The treaty remained binding until a breach was proven, and procedures under Article 65 to 67 followed. Furthermore, the procedural rules for suspension require that the injured party must notify the other allow a reasonable period for response and seek negotiation for a third party review. Botuna invokes Article 62 of the BCLT, claiming that climate change has fundamentally altered the context in which the treaty has concluded. It argues that the environmental safeguard built into the original agreement are now outdated and ineffective, and therefore it should not be considered a breach of the treaty for adapting or disregarding those outdated terms. Under Article 62.1, a treaty may be terminated or suspended if there has been a fundamental change of circumstances, and that change must be unforeseen, and it must constitute as an essential basis of consent, and it must radically transform the obligations still yet to be performed. Botuna's reliance on Article 62 of the BCLT, claiming a fundamental change of circumstances due to climate change, is unlikely to be legally valid. While Botuna argues that environmental shifts have made the treaty's safeguards outdated and impractical, this fails to satisfy the strict requirements of Article 62. Climate change is not an unforeseen development. It was already well understood when the treaty was signed, as the ICJ clarified in Gabichoko Nagimeros. Moreover, Botuna continued to operate under the treaty without formal objection, undermining its argument that its original consent had been fundamentally altered. The obligations of the treaty had not been radically transformed. They remain performable even if some provisions require updating. Crucially, Botuna failed to use any built-in mechanisms for review or renegotiation, making his unilateral claim under Article 62 both procedurally and substantially weak. Gabichoko Nagimeros, in that, Hungary argued that developments in environmental science constitute a fundamental change of circumstances, and that the ICJ rejected it, stating that the evolution of environmental standards and awareness cannot be said to have been completely unforeseen. Similarly, in the Aramika-Botuna Treaty, the parties likely anticipated long-term environmental shift. If Botuna considered the safeguards were outdated, it should have invoked renegotiation provisions, not refuse compliance altogether. Furthermore, this is a high bar. Outdated safeguards may need updating, but does not make the entire treaty unworkable or its core purpose impossible. Fisheries jurisdiction case in that UK v Iceland, Iceland argued that the increased importance of fisheries to its economy and new environmental awareness justified its withdrawal from earlier agreements. And to this, the ICJ held that the economic and environmental shifts did not justify invoking Article 62 because the alleged change was neither unforeseeable nor radically transformed the obligations. Similarly, Botuna's situation doesn't meet the radical transformation threshold under Article 62. Botuna argues that the treaty is void under Article 64 of the BCLT, claiming it conflicts with the newly emerged Jaskugan norms, the right to access clean water. It cites a UN General Assembly resolution that recognizes water as a human right and claims that Aramika's diversion of river water violates this emerging norm. However, this argument fails on multiple legal grounds. First, the right to water is not currently recognized as a Jaskugan norm. In Bosnia and Serbia, the ICJ affirmed the prohibition of genocide as a Jaskugan norms, but did not extend such status to economic or environmental rights. The threshold for Jaskogans is extremely high, requiring universal acceptance and non-derogability in water rights, although important, have not reached that level. This was made clear in the Silila River dispute between Chile and Bolivia. Bolivia attempted to frame the dispute in terms of sovereign control and equitable access to water, hinting at fundamental rights. However, the ICJ did not elevate the right to water to Jaskogan status in the case. Instead, the court focused on customary principles of equitable and reasonable use of transboundary watercourses, not on preemptory norms. This confirms that the right, while increasingly acknowledged, remains within the domain of negotiable and context-dependent obligations, not preemptory law. Moreover, Even if access to water were hypothetically recognized as Jussoans, Article 64 only voids a treaty if its provisions directly conflict with the norm. However, the treaty does not deny access to water, it establishes a shared dam project and a cooperative framework. The issue lies in how the treaty is implemented, not in the treaty itself. This approach is backed by Gobichoko Nagimeros, where the ICJ emphasized that environmental and sustainability concerns should be accommodated through cooperation and treaty mechanisms, not used to invalidate the treaty altogether. In conclusion, Botuna's claim under Article 64 lacks legal merit. The right to water is not yet a jus cogens norm, and even if it were, the proper remedy would be in renegotiation or operational adjustment, not voiding the treaty. The dispute between Aramika and Botuna reveals how key treaty principles under the Vienna Convention don't function in isolation. They interact dynamically, shaping the boundaries of what states can or cannot do in managing treaties. At the basis, Article 26, Pacta sunt servanda, the principle that treaties must be honored in good faith. This ensures legal certainty and holds the international system together. But the law also recognizes that treaties aren't infallible. In exceptional cases, this principle can be overridden or displaced. One such exception is Article 60, material breach. This allows a state like Aramika to suspend a treaty if the other party commits a serious violation of its core purpose. But here, Pacta sunt servanda acts as a threshold gatekeeper. Material breach only applies if the breach is proven, fundamental, and procedurally addressed. If not, the default rule holds firm. Then comes Article 62, fundamental change of circumstances invoked by Botuna. It doesn't override Pacta sunt servanda directly, but instead modifies its application by arguing the original basis for consent has collapsed. This principle states in the middle, less rigid than Pacta sunt servanda, but more restrained than material breach, allowing for treaty adaptation, not termination by whim. Finally, at the top of this hierarchy is jus cogens, preemptory norm that override all treaty rules, including Pacta sunt servanda itself. Under Articles 53 and 64, if a treaty conflicts with jus cogens norm, it is void and or becomes void. However, jus cogens is rarely triggered only when a universally recognized norm like genocide or torture is at stake. In this case, all three exceptions fail to surpass the strength of Pacta sunt servanda. Aramika's claim lacked proof of material breach. Botuna's climate change deference was foreseeable and not radically transformative. And the right to water, while morally compelling, is not yet recognized jus cogens norm. Ultimately, these doctrines form a legal ecosystem. Pacta sunt servanda ensures stability. Material breach and fundamental change provide flexibility, and jus cogens sets moral boundaries. But each operates in clear hierarchy, and none can be used carelessly. To avoid future disputes like the one between Aramika and Botuna, I propose 5 key recommendations rooted in treaty law, environmental adaptability, and international cooperation. First, future treaties should include mandatory review clauses. In an era of climate uncertainty, states need built in opportunities to reassess obligations every few years. This allows treaties to evolve with science and environmental data, reducing reliance on drastic doctrines like rebus sic stantibus. Second, I recommend establishing a joint scientific and compliance panel, a permanent expert body made up of representatives from both states that can monitor the dam's environmental impact, assess compliance, and recommend technical updates. This promotes cooperative adaptation and prevents the kind of factual disagreement that we see in this case. Third, there must be a clear procedural safeguards for invoking material breach or fundamental change. Treaties should specify steps such as formal notice, a waiting period, or neutral verification before suspension or termination is considered lawful. This would prevent states like Aramika from acting unilaterally without accountability. Fourth, the international community should support progressive recognition of environmental principles as jus cogens. Judge Veeramentry viewed sustainable development not as a right in itself, but as a means for resolving disputes to the rights to development and environmental protection. The underlying juristic basis of sustainable development is therefore the reconciliation of the tension between environmental and development rights. And finally, I recommend the use of binding dispute resolution mechanisms. Instead of unilateral suspension, parties should be required to submit to disputes to arbitration or to the ICJ. This upholds Pacta sunt servanda while offering a lawful path to reserve deadlocks. In short, future treaty framework should be scientifically adaptive, procedurally disciplined, and normatively forward-looking, balancing legal certainty with environmental responsibility. In conclusion, the case of Aramika and Botuna illustrates the delicate balance that treaty law must maintain between legal certainty, procedural discipline, and the need to adapt to challenging global realities. While Pacta sunt servanda remains the anchor of international law, exceptions like material breach, fundamental change of circumstances, and jus cogens must be invoked carefully with clear evidence and strict compliance with legal safeguards. This case reminds us that treaty law isn't just about rules on paper, it's about how states apply those rules in good faith with respect for both of the letter and the spirit of the law. Ultimately, international cooperation, not unilateralism, is the key to preserving treaty integrity in an evolving world. Thank you.